Hello, good afternoon, colleagues, and welcome to today's training session on jury trials. The Greater Accra Bar, in conjunction with the Criminal Justice Committee of the Judicial Service, is pleased to bring you this training. For today's training, we'll have Her Ladyship, Justice Afia Serwah Asare-Botwe of the Judicial Service, of the Court of Appeal, leading us, facilitating this training for all of us. For today's session, we'll have our Vice President, Mr. Andrew Apa-Obeng, moderating the event for us. And without wasting any further time, I would hand over to our Vice President to take over and moderate. We intend to do this within an hour and 30 minutes so that we can get back to our regular schedule. Thank you.
Okay, so thank you, Joe, and thank you, members of the Greater Accra Regional Bar, for your time. Now, as already introduced, the program is going to be in two segments. So we'll have the first part, which will be an hour presentation by our guest speaker, after which we have the opportunity for question and answer session. Now, members, whoever have any questions that you have, you can type it in the chat box so that after the presentation, we'll take our time to go through and get a response. So in order to ensure that we get the best of the day, we'll hand over to our guest speaker, Her Ladyship, Afia Serwah Asare-Botwe, Justice of the Court of Appeal. Thank you.
Good afternoon, everybody. I hope you can all hear me, please.
I'm sure we can all hear.
Okay, and I'll begin by sharing my screen. Please, can everybody see the screen?
I need that too.
All right, thank you very much. Today we are supposed to be discussing some new reforms that we have and what we need to do to make our jury trials more effective. But before I go on, let me express my greatest appreciation for all of you for being here. Last I checked, there were 233 people on this meet, on this Zoom. I know that the number is going up. We absolutely appreciate your being here. And I have to say also that it is imperative that you get to know what is happening. Because after all, if we tickle ourselves and laugh and imagine that we are doing a lot of work, but major stakeholders, that is the lawyers. When we talk about lawyers, we are talking about prosecutors and defense lawyers are not on the same page. We won't be doing anything. So the time is not much, but I hope I'll be able to communicate the plan that we have and how we think our jury trials will become more effective. I mean, who doesn't know how the kind of problems we've had? But let's just quickly look at the agenda for this afternoon. We want to look at the legal framework. Now, because you are lawyers, we will not deal into we'll go into much detail with the legal framework because there's nothing I can tell you that you don't already know. The focus of this meeting, though, will be the problems that we've been having, the solutions, and what we might think might be the challenges, the way forward, and then we'll have a quick summary. Now, quickly, just for us to have a look at the legal framework. We all know the basis for jury trials. Every one of us on this platform has done enough criminal procedure to last many lifetimes for some people. So, in essence, any offense other than treason and high treason, whose punishment is death or life imprisonment, has to be tried by a judge and jury. And we also know about other first-degree felonies like rape, currency offenses, and so on, which are classified as first-degree felonies, which have to be tried on indictment and which have to be tried by judge and jury. We all know about where the punishment is death. We know that the verdict shall be unanimous. And where it is a life imprisonment, then we need a majority. We know that the majority is determined from time to time by Parliament. And as we stand now, we know that the majority ought to be 6-1 or 7-5-2. Anything worse than that, 3-4 and so on, would bring about a hung jury, which would demand a retrial. Well, we all know these things already. We all know about the qualification of jurors and the preparation of jury lists. I think we all know that 25 to 60 age, 25 to 60, and if the person can speak English, the person will be subject or will be qualified to be a juror. We also know about the exemptions in Section 207 of the Criminal and Other Offences Procedure Act. The 207, all of us on this platform are exempt. Lawyers, judges, doctors, pharmacists, people in the post, and so on. Civil servants, other than those in the clerical class. So we all know about the exemptions. We also know about the exemptions relating to people who have been convicted for offenses that are either felonies or treason or high treason or any offense involving dishonesty. So we know about these exemptions. How have these exemptions been playing on us? I think the problem is that for a long time, the exemptions have been causing us in the criminal justice sector to limit the kind of people we would have as jurors. So what do I mean? Over time, because there is the exemption of people in public service or in other than clerical staff, we have only chosen jurors from clerical staff in civil and public services. That's what we've been doing all these years. It has to be clerical staff in civil and public services. I don't know why. Now, we have also had a problem. The yearly revision of lists required under Section 213 of Act 30 has not been efficiently done. If we had done it efficiently, we would not have had the same jurors coming in and being on jury lists for years. So we have found that due to the limited number of jurors, because we have only chosen them from civil and public services, we have found ourselves also having a limited number from which the ballot can be picked to empanel the juries. So we find, for instance, here in Accra, there are 4 criminal courts or 5 or so. We have only 35 or 40 jurors. So we have found that actually the choice that the accused persons have is almost no choice at all. Very limited, because if we have 30 or 35 jurors and we take the same people to be balloted for, we find that they are picked up and empaneled by almost everybody. I don't know whether because the choice is so limited. I mean, if they put food before you and they ask you, do you want kenke or do you want kenke? You have to eat kenke because that is the only choice that you have. It's the same thing we've been having. So we have also found that because of the limited numbers that we have, a particular juror may be involved in several cases. So we have one juror, for instance, being involved in one case in court 1, another case in court 2, another case in court 3, and even in some regions, one juror may even be empaneled to sit on as many as 20 cases in several courts. And then it makes the jurors and the courts themselves ineffective. What do I mean? A case is called, a juror, the juror has been empaneled in court 1. Same juror empaneled in court 2, in court 3. So as you are actually adjourning the case for hearing or for trial, whatever, the juror says, I'm involved in another case. I have this case here, this case there. So actually they show up. The jurors actually show up for work. They come to court, but we are not able to do much because the other alternative would be for the judges to have them sit for maybe an hour or 30 minutes at a time and release them to go to the next place. So we were just ineffective. Then comes the never-ending jury duty. There was no beginning and no end to, because there was no criminal sessions. So a juror may have been empaneled and would be serving for up to a decade, now sometimes more. And I have always asked this question, that if we look at it, our training is for 6 years altogether for modern lawyers. In our time, it was for 5 years, because we did our degree for 3 years, law school for 2. Anyone who has been around the courts for 10 years and so on is almost a professional. Such a person knows too much of legal systems. Meanwhile, we need lay people to be able to sit as jurors. And the other point is that how these jurors were going and coming year on year, that is not what the law envisaged it to be. So what then was the proposal? The proposal was that we expand the jury list to include any citizen qualified by law, including citizens in the private sector, because there is no reason why we need to exclude any group of citizens and insist or maintain just people in the civil and public service and in the clerical class. So that is the proposed solution and the reform, that we have now expanded the jury lists. So in places, instead of 30, 35, we have 180, 200, 250. Accra, I think we have 250, Kumasi 250. Our jury lists have now expanded such that there is no need for one juror to be involved in more than one case at a time. But that also has implication for how we will run our work. Because if we are going to get people who are in private enterprise engaged in jury duty, we cannot waste their time and we cannot not be serious. We need to deal with the cases quickly and conclusively so that they can go back to their lives. And that is how we thought about it. It was Cape Coast that we got the solution from. Cape Coast was the region where they expanded the jury list first, because initially we were trying to see whether we could get data from the National Identification Authority or GRA, because those kinds of data can have, the jurisdictional data that we need, because we need people who are close. But it was difficult for us to get it. And while we were still thinking about what to do, Cape Coast just thought, why don't we write to every institution and ask them to submit their jury list? I'm sure many of you may have seen that we did a lot of public sensitization on radio and TV. This is the reason, because we wanted people to be prepared in their minds that anybody who is qualified under Act 30 may be called upon to do jury duty like it is done in other jurisdictions. So for that reason, Her Ladyship the Chief Justice has issued some administrative directions to help us to get the work to be more effective and speedy. So the first thing is that the registrars of the High Court are to help by making sure that no juror is on the list of more than one court. So of the 150 or 200 or 250, there will be 50 in each court, out of which the ballot would be taken. So we will not have the people being mixed up such that one will be in one court, more than one court. So every juror must be on only one list, and they must be on just the list of one court. So the possibility of any juror being involved in cases pending in more than one court would then be eliminated. The next thing is that the trials, and this is where you come in, the trials are to be conducted from day to day, all day, such that the courts would determine one case from start to finish within a few days before beginning the hearing of another. And it is the same as happens in most other jurisdictions. And I think it happens a lot in a lot of courts. We have only not been able to do it in our trials on indictment obviously because we have managed to mess up the schedules of the jurors, so they couldn't be in one place. So now the trials are to be dealt with from day to day, all day. So we come in the morning, we do the cases, and then we close by evening and until the case is done. How do we do it? I think there are other methods other things that we need to pay attention to, but we did a certain assessment and realized that in a lot of the trials on indictment, the average witness count would be 4. In some regions, it is 5. And if we are doing the cases from day to day and we are even taking 2 witnesses a day and so, which is not extraordinary at all, because coming from my experience as a trial judge, I have had instances where I have heard 3 witnesses in one day. So you are having a doctor who is just coming to tender a medical report, or we have somebody who is a ballistic expert coming to just tender in a report on the gun or something like that. It's nothing complicated. It's not long. 2-3 people in one day is not impossible. So that is the plan. Next, we are supposed to have a formal criminal assizes or criminal session. I know that many of us who started our practice in the 90s and early 2000s used to experience this opening of criminal sessions. So the session opens, we prioritize the cases, we close the session, we discharge our jurors, and then another set of jurors may be invited to come in. So the judges have been told and directed and trained to comply strictly with that practice direction on effective case completion strategies 2019, the one at the volume 1 of 2017-2021 Supreme Court of Ghana Law Report 422. I think anybody who has done case management in my court knows the practice direction I'm talking about. And then that one also has the timetable, the case completion plan. That is what the judges have been told to strictly adhere to. We also have a practice direction on jury trials, which I will share with you. I will share with your hierarchy so that they will put that on the platform. All these practice directions I'm referring to will be shared on your platform, please. Now, the prosecution and registrars, there's something else. Then everybody is asking, if this is what we are going to do, how are we going to manage disclosures? The disclosure, we understand, is mandatory because of the decision in the Public versus Eugene Bafuboni. And the timing of disclosure is important in this matter. In the Supreme Court decision, the question was asked about whether disclosure would cause delay and overburden the prosecution. Now, what Her Ladyship Adinyira said was that if the prosecution voluntarily discloses materials to the accused, there will be fewer delays. When should the disclosure be done? Why should we wait for the accused person to be arraigned before the court before we do the disclosures? Now, if we look at what is a cut-head criminal case, let's look at the technicality of it. In criminal jurisprudence, the moment an accused person's plea is taken, that would constitute the case into a part-head case, the moment the plea is taken. So why do we wait for the plea to be taken before the disclosure is ordered? Why would we not even front-load the disclosure to the accused person before the plea is taken, such that if the accused person wants to take advantage of a guilty plea or some kind of plea bargaining, after the accused person has actually studied the record or the disclosure, the accused person can. Why do we have to wait until the plea is taken? So with that, going forward, the direction is that disclosures are to be filed in full before the cases are listed before the courts. Because until the disclosure is done, it would not be fair for them to take their plea. And in any case, it is technically a waste of time. The reason is that whatever happens, Even if they plead guilty in some of the offenses, we may not be able to accept a guilty plea. So in such a case, it's better for them to be given the disclosures in full. So going forward, the direction that has been given is that disclosures are to be filed in full before the cases are listed before the courts. In the alternative, jurors should not be summoned or empaneled until the disclosures are completed. Because if we look at it, why do we call jurors? Only for them to come and sit and take their allowances that are due them, when we know that practically the case cannot be commenced because the disclosure is not complete. It is a waste of resources, waste of their time. And I'm not saying that public servants could have their time wasted, but we all know that the stakes are different for people in private enterprise. So we are saying that now the earlier disclosure is done, the better it is for case management and the avoidance of delay. So to sum up, we will only do case management, which would mainly be time management, how to manage the case and the time for everyone to know exactly what it is that we are doing. So the practice direction directs that a trial period be fixed. So we are going to fix a trial period. So when the plea is taken and then the jury is empaneled, we know that maybe we are starting the next day from day to day, 4, 5 days, 20 days, whatever. But the direction is that under no circumstance should any case last for more than 30 days. So that is the new direction. Now, we all know about the case completion plan. It's in the book, in the Supreme Court of Ghana Law Report, but there's a slight difference because of the trial that we are conducting with a jury. So with the case completion plan, the jurors' names would also be included and they will sign at it. But we all know about these case completion plans, which I think we've all been signing. So it is nothing new for us. It's the same thing that we've been dealing with. Please, for those in doubt, please refer to the 2017-2020 Volume 1 Supreme Court of Ghana Law Report at page 422, and you'll get enough information. Now, still on going forward, on the trials by with the aid of assessors also, we are saying that in offenses that are not punishable by life sentences, but are triable on indictment, such as rape, the judge may direct that the trial be conducted with the aid of assessors instead of with a jury. We have all learnt in criminal procedure that we can try cases with the aid of assessors, but we never do it. We learnt it, passed our exams in criminal procedure, and then we put it under some place to cool. Now, the judges may be direct. It is for the presiding judge to direct that the trial will be held with the aid of assessors. Now, in that case, the judge has a choice of not selecting not less than 3 assessors. So the judge can choose 3 people, 5 people, 7 people to assist. Of course, we know that assessors render an opinion while jurors deliver a verdict, and the effect is not the same. But then, since the qualification of jurors and assessors are the same, the assessors may be drawn from the same pool. And at the end of the day, whatever the judge would do to effectively manage the case for a speedy resolution of the case is what the judge is supposed to do. So if, for instance, we have a rape robbery case, it is not something in which somebody died, but it was a robbery in which some people were raped. That can be tried with the aid of assessors, because you know that the punishment for robbery has been, what's the word? Prescribed. So now we know it. So we should consider that. And if any of us should have a judge direct that the trial will be conducted with the aid of assessors instead of with a jury, it should not be strange because the law accommodates it. Now we are also directing that the judges ensure strict compliance with sections 222 to 224 of the Criminal and Other Offences Procedure Act. Why? Because last year, I don't know how many of you were aware of jurors who decided to go on strike. And It should not be so, because the law takes care of it, because we know that a person commits an offense and is liable on conviction to a fine not exceeding 120 penalty units, who is summoned to attend court as a juror and does not, without lawful excuse, duly attend and be present at the court and at the times appointed by the court for adjournment, or who is present but refuses to serve. So they will be in the room, and many of them were there. They just refused to go and sit where the jurors are supposed to sit. It should not be so. People are saying, but what about the allowances? There's nothing in legislation which talks about allowances. In any case, normally these allowances, it's like that for most other institutions. It is when the work is done that you present the documentation for them to pay the allowances. It's like that for many institutions, even for the judiciary, for example. It is only 2 days ago that I received my fuel allowance for the last quarter of 2024, or third quarter, last quarter of 2024 or so. So these allowances should not be an issue that would make them not work, especially when we are having a problem of the jurors showing up, being divided so much that we are not even able to get the cases done. Last year, I understand, and I asked from the Ashanti Bar when I went to hold a similar meeting with them in Kumasi. They were not even able to complete one case because the jurors are so divided. I'm not even sure whether Accra was able to complete even 5 cases. It is that bad. So we need to find a way. So these are the legislation. This is the legislation on non-compliant jurors, which the CJ has directed that we should pay attention to the provisions in the Act and just abide by them. So how the compliance would be, I think this group is not the group that I should be discussing juror compliance with, because you all have the act and you know it. Some of you know it better than I do. So let's move on. So further, we have directed that if a juror has been empaneled and fails to attend court on a particular day, the allowance payable to the entire panel of jurors will be forfeited, as no work would have been done to warrant payment. In this regard, we have asked the foreman to ensure that the work is done. That is whenever they are empaneled. Somebody is asking why. Let me explain. I think many of you work as corporate lawyers. Some of you also do external work for companies. And you know that whenever there is any meeting, and you show up at the meeting and there is no quorum, for which reason the meeting is unable to proceed, we all know that nobody gets paid a sitting allowance. It is the same principle that is being applied here. If there is no quorum because a member of the panel is absent, naturally, there should be no payment made, because the work was unable to progress. I am sure that with this, people will be able to communicate such that I am sick, I have a medical report, any of that, they will be able to communicate ahead of time. But for people to show up and not do any work and get paid, I don't know how many of you are aware of how much they are paid. But for every day that they show up, I think it is 100 cedis. And for every time they sit on a case, once the panel is there and they call the case and they come and stand there present, 200 cedis, 300 cedis per juror, 7 jurors, 2,100 cedis per day, per court, per case, per court. So you can just, my math is not good. Just wrap your head around the kind of cost that we have incurred without actually getting any work done. I don't think any institution, and any institution which is a serious institution, should not be throwing money down the drain in such a manner, especially when we are not yielding any results. Now, please, another thing, we need to look at the accused persons on bail. Accused persons on bail would have to pay attention to Section 96 of Act 30 on the conduct of an accused person who has been granted bail pending trial, and making sure that they show up. We also know about the constitutional provisions relating to trials in absentia, how a bond may be extracted after which applications may be brought for an accused person to have the case continue in absentia. These are not matters that are strange to our jurisprudence at all, but for some reason, nobody has been ready to use them. Now, the proposal is that we should go back to what the law is and just abide strictly by it. So we are going to go by Article 19.3. I think we have a lot of cases on that, on trials in absentia. I myself, I think I have two from the High Court. So these are things that can be done. We can continue the proceedings in the absence of the accused person if he or she fails to turn up. And so once it is established that the accused person is aware of the date, the case is to be heard, and is absent without any just cause, the trial may continue in the absence of the accused person, subject to the issuances of the notices and etc. and so on. I think we have enough jurisprudence on that, so I'll not waste your time. Now, for us colleagues, and this is the part that would relate to you, that the judges are to ensure strict compliance with the professional conduct and etiquette rules. So misconduct would be as follows. For prosecutors, it would be a misconduct if they do not do full disclosure. So they are these are the prosecutors rules, the prosecutors rules. So a prosecutor, as soon as practicable, disclose to the opposing party every material available to the prosecutor. And that is the thing. We cannot have our prosecutors hiding the disclosures and being called upon and prevailed upon. Please file your disclosures, no. So any information that is within the purview of the prosecution, anything that may be relevant or exculpatory is supposed to be disclosed. So unless there is some integrity issue, which we all know which are very clearly set out in the Bafo-Bonny decision. So still, anybody who may have any, if on the other hand, if the prosecutor intends to use any information, so even after disclosure, if the prosecutor gets some information that they intend to use, we know that the disclosure should be of a continuing nature. They shouldn't keep it only for an accused person to now need an adjournment to go and study something. It should be made available to the accused persons, especially if there is an issue relating to unlawfully or improperly obtained evidence or any such thing. These are all in the professional conduct and etiquette rules. Now, if the prosecutor fails to assist the court in line with regulations 56 and 57, and it occasions a delay in a jury trial, that would constitute a professional misconduct. Then, so we have discussed negligence and delay. And we all know it because we've done enough of ethics that I don't have to be the one to, far be it from me to speak about things that you already know about. But if a lawyer misconducts himself and the lawyer also fails to attend court or does not arrange for another lawyer to be present or does anything to delay the cases, then the judge reserves the right to refer the said lawyer to the General Legal Counsel for disciplinary action to be taken against the said lawyer. We also have a part for the police officers to play. We have discussed this in the different fora. I think this is the 6th meeting I'm having with stakeholders. In all other meetings, we have invited the police prison officers to be present and to participate in the meeting. So if a police officer misconducts himself by not making sure that the witnesses are present and so on, the judge shall take steps through the judicial secretary to have the police officer reported to his hierarchy. And in the same manner, if any judge notices um, work that is worthy of commendation, the judge is supposed to do so. The prison officers too, we have a similar provision, especially for those who are keeping our accused persons. Now, the keepers of the prisons are supposed to assist us in making sure that they bring our accused persons when they should. And then if they do not, we are supposed to report them to the hierarchy. And if they do, and they work properly and over and above what is expected, we are supposed to also commend them. Now, our witnesses, where we have witnesses who are not complying with attendance, even after they've been served with subpoenas, witness summons, and so on, we have asked the judges to strictly comply with Act 459 and make sure that they get the prosecution or the defense or to secure the attendance of the witnesses, either voluntarily or by service of a subpoena or witness summons. So if a witness is subpoenaed and fails to show up, the judge knows that they are supposed to issue bench warrants for the arrest. It's not for them to decide that they don't want to come. And so there's power to summon a witness on the court's own motion or by an application by a party is very clear. And then we are looking at compelling the witness to attend court by way of a bench warrant. And then there is a penalty for a witness's non-attendance. A judge in such a circumstance is to impose the fine of 50 penalty units or 6 months imprisonment or both. Now, in summary, and I think I'm almost done. We all have our parts to play, the judges and magistrates. For the magistrates, our work has been for them to make sure that the committal proceedings are properly done. And once the committal proceedings are concluded, to transmit the documentation. It was shocking that some people had not transmitted documentation for more than 6 months to 1 year, when the rule is very clear that they are supposed to do it within 14 days. Everybody was just lying down doing nothing. Now, the jurors are also legally bound to attend the court sessions, and they are supposed to be penalized if they don't. For accused persons on bail, if they are supposed to be in court, they should be in court. If not, everything is an option, including trials in absentia. And our colleagues at the bar are requested to assist in proper, efficient conduct of trials. And if there is the need for judges to report them for professional misconduct or for the state attorneys keeping information, then they should do so. So please, that is what we are working with. Now, we're still concluding. The police and prison officers play a crucial role. So we are supposed to make sure that if they cause any delays, they are referred for disciplinary action. And of course, what is a trial without a witness? If there's a trial and the witnesses are not there, and the prosecutions are supposed to produce them, and the defense and their timely appearance, please, we are all required to do our bit, and then we can move forward. And that will be it. Can we have your questions, please?
Thank you very much, Your Ladyship. There's the first question is that what happens when a case somehow exceeds the 30 days day-by-day trial? What happens, my lady?
Also, there should not even be an issue like that in practical terms. In practical terms, what do I mean? Let me give an example, just how we envisage a case can run. So on the first day that the case is called, the accused person pleads guilty. Oh, sorry, not guilty. The remember that the disclosures have been front-loaded even before the accused person shows up. Then the accused person pleads not guilty. We commence the empaneling. The first person is called, second, third, requisite challenges are put up, whether it is for cause or peremptory, whichever way it works. We have the panel. As soon as the panel is in place, that same day, the judge is supposed... Can you hear me, please?
Yes, lady, can hear you.
Okay, so that same day, the court does the case management. Because remember, the disclosures have been done, the prosecution has it, the defense has it, the court has it. The court is aware that it is 4 or 5 witnesses they are calling. So they have to do the case management that very day. In fact, if the court is supposed to be on its feet the way they should be, because I remember when I started prosecutions in 1996, we were calling PW1 on the first day. And that was without any complicated case management. So if the case completion plan is done, even the very first day, a witness may be called. Because remember, and I keep saying remember, because disclosures have been front-loaded, this is not the time for lawyers to now ask for to go on and have conference. Because whatever conference needs doing would have been done already. Because disclosures have been front-loaded, witness statements, everything has been given to them, even before they are arraigned before the courts. So this is not the time to ask for an adjournment to go for conference. This is not the time to ask for an adjournment or to see any witness or anything. Because whatever information we need has been front-loaded already. And then you can call first witness on the first day. You can even call a second witness on the first day. Then the next day, too, the prosecution closes its case. Now, once the prosecution would have closed its case, maybe after the second or the third day, assuming the accused person wants to make a submission of no case. Now, there is something going on that we have discussed at length. I'm not sure it is going to be repeated. Who does written submissions in a trial on indictment? How? Why? Because in a trial on indictment, you ask the jurors to excuse you. The lawyer goes ahead to do his submissions orally. The judge then determines it in a few hours or by the next day. And then if there is a need for the accused person to open his defense, the judge, immediately the ruling is read that the accused person has a case to answer, now proceeds to go ahead and do case management for the defense. And then you start either the same day or the next day, from day to day, 5 days, 4 days, 10 days, it should be done. Now, I don't understand also how closing submissions can be done in writing. Who does closing submissions in writing when the jurors are not lawyers? Are they reading the closing submissions? Do you let them file the closing submissions for weeks, only for them to come and read the closing submissions to the lawyers? No. So we've discussed it at length, that closing addresses, is it 562 participants I'm seeing? Wow. So, wow. So the closing addresses would be done orally because it is supposed to be addressing the jurors. Then after that, we can carry on from there. So it is not, unless it is an extraordinarily long case involving 15, 20 witnesses. But if you should look at the average, and it is the average countrywide, the average for trials on indictment, average numbers of witnesses, 5. I mean, who goes to rape somebody and will be announcing, I'm going to rape somebody, I'm going to rape somebody, so let's go. So it will naturally be fewer numbers. 4, 5, that is the average, except for extraordinarily complicated cases and extraordinarily complicated conspiracies. But it is usually 4 or 5. Thank you very much. Please, I would like to, you have more questions?
Yes, please, there are more questions coming in. And this question is from David Koko Esquire. It's quite long. And this is his question. Considering the duty imposed on the judge under Section 271 of Act 30, should he or she leave a case to the jury if he or she was of the opinion that there had been no evidence to prove an essential element in crime, or the evidence adduced by the prosecution had been so much discredited as a result of a rigorous cross-examination?
Yes, Mr. Koko, of course, as usual, you are brilliant, Mr. Koko. So it is at the end, at the close of the prosecution's case, the judge is supposed to make a determination as to whether or not the case has been sufficiently made by the prosecution to merit the accused person being called upon to answer. That has not been taken away. What we are doing right now is very simple. We are only trying to manage the time for the cases such that we will not have jury trials lasting for so long. That is all we are doing. The legislation has not changed. You know, I don't know who does not know this, but I have always been saying that our legislation is very old. The 1960 legislation demands an overhaul. There are many things that are happening in modern times that have to be taken care of by legislation. For example, let's look at preservation of evidence now. Shouldn't we be thinking of technology, preserving evidence by taking videos of somebody who is nearing death, but who has something to say in a trial? Should we still be commissioning evidence with people crossing rivers and crossing bridges and crossing fires? Should we not have technology such that, you know, all those things about having to take evidence via video link, consistently having to go to the Chief Justice for a warrant to be able to take evidence via video link, all those things. But then, until we get the legislation overhauled or maybe amended, should we not just look at the legislation as it is and try and do something, you know, make lemonade out of lemons? At present, that is all we are trying to do. We looked at the legislation as it is now, and we thought about how best we can use the legislation in its current state. And that is what we are trying to do. So all those matters have not been done away with, but we should consider this. Why should we, in a jury trial, for example, have anyone order that, yes, the person is using witness statements, but we cannot read the witness statement in open court? We have to read the witness statement in open court because the jurors have to hear what it is that the witness has written. The jurors are not lawyers. We are not supposed to be bombarding them with paper. We are just supposed to be helping them to listen to the evidence, and then we carry on from there. So they are supposed to, for instance, have the jury listen to the witness statement. And then once that is done, we carry on. If it comes to any part where it is submissions, closing addresses, opening addresses, and so on. In a jury trial, for example, there is no need to give facts. You don't give facts in a jury trial. You give an opening statement. The prosecution gives an opening statement, and the defense also gives their opening statement. And then we carry on from there. That has always been the practice. With the new filing of stuff, I think some of the things are getting a little lost in translation, but that's not how it's supposed to be. And I think we have done quite a bit of discussions and trainings, and hopefully we should be able to see a drastic improvement in the work that we are doing. Thank you.
Lady, we have more questions, and this time the question is, in practical terms, how does an accused person mount a challenge for cause when the accused person does not even have an idea who the juror is? Lady.
So we will have the jury lists. Actually, I have directed last week when we did the meeting, which many of you were not able to attend, the issue of having practical challenges for cause came up. You know that hitherto the challenges for cause, we've not been doing much because nobody has been able to do proper background checks yet. So we've not been doing much. People just decide for some strange reason that in a rape case, they don't want a young lady on their panel or something like that, but you don't even really know them. So I think we need to give them the names. The problem though is how to prevent people trying to contact our jurors. I hope you understand me. We cannot deny that there will be some people whose spirit is not good, who will want to contact the jurors, but there should be a way of having some background check on the jurors. If they want to cyber stalk them, they want to check their Facebook, because you know that in other jurisdictions, jurors have made comments on their Facebook, which has caused them to be asked to step down. Because, for instance, say if a juror makes some outrageous comment, like kill all the men, such a juror should not be on a rape panel because they are ready to kill all the men, you know, that kind of thing. But I think that once you get the information, the jury list should be available soon. We've got the list. We were trying to hive off their contacts, you know. We don't want their email addresses on it. We don't want their telephone numbers on it. And then with that, maybe you will know what to do. If we had been able to get the jury list from the National Identification Authority, so that their list would have come with photographs, the way we had wanted it the first time, maybe it would have been more helpful. But we are taking baby steps. So I'm sure that going forward, things will improve over time. Thank you very much.
Thank you very much, Milady. As a follow-up question on the challenge for cause, is there a procedure for such a challenge? Is there any laid down procedure, Milady?
By the way I teach it, I know that a challenge for cause can be mounted on certain basis, for instance, on real or perceived bias. So if, for instance, somebody, you know, in some places, when the jurors are asked to come in and they are being empaneled, they question the jurors. For instance, do you believe that people should dress in a certain way? Do you understand? They ask them certain questions, which gives you a basis for you to understand, for instance, that if, for instance, somebody is dressed with a slit up her skirt or the skirt is short, then that person deserves what comes to them, you know, that kind of thing. So in some jurisdictions, they ask them questions. Here in this country, we've not had real challenges for cause. We haven't, because our people have not, we have never tried to do anything really to get to know the jurors enough to be able to challenge them for cause. But then, let's see, we keep making the law every day. So within the legislation just mentions challenge for cause and peremptory challenge. And the basis for the challenge for cause, we have just 1 or 2 cases in EMISA. But beyond that, we have not had a practical procedure. Notice that there's no LI to Act 30. There's no legislative instrument, proper legislative instrument to Act 30, which gives basic methods and modes of doing things. There's none. So it is just the legislation as it is. But the house and the wherefores of the use of the legislation, we've not got it yet.
Thank you, my lady. The next question is, with respect, whose duty is it to ensure that the accused is brought to court from detention? And whose further duty is it to provide for fuel expenses? Is it the state or the family of the accused, my lady?
We all know it is the republic, it's the state. I know that there might be practical difficulties, but you know that before I became a judge, I was the head of the AG's office in Sunyani. And I said that Under no circumstance will we take anybody's money for anything, because it is a risk no state institution should take, and that we should make sure that they are brought. It is also the cost of this, the cost of the republic, that the witnesses are brought, including even practically by law, witnesses for the accused person. Accused person's witnesses are to be produced by the republic. If the accused person's witnesses cannot be found, it is the republic which is supposed to make sure that they find them. But it is not an easy thing. Speaking as someone who used to man a region, by the time I was leaving in 2013, I had incurred a personal cost of 6,000 Ghana cedis. I was never able to get my money back. Now, who goes to work and puts their money in it? But it is for the state to do it, and they are supposed to make provision for it. That is the law.
My lady, and thanks for generosity in using your personal funds to help with the prosecution of accused
My
person.
husband got tired of asking him to pay for stuff. But you see, if you want the work to be done, sometimes you want to put in your personal resources just because you want to be effective. It's not because you see, you have already empaneled the jury. You already have people you have to call. You call them, and in the hope that when all is said and done, you'll be able to claim for the money back. I'm sure that if I had not left the AG's office, I would have gotten the money back. But it's because I left, and once I became a judge, I couldn't go to the Attorney General's office for my money. But if I had stayed, I'm sure I'd have my money back. So if they would, usually you would pay, and then eventually, when the interest comes, you would get your money back. So they may have to put up something, but they will get their money back.
Lily, I'll come to you for your invoice before you left the AG's office and go and see if I can claim for you.
Oh, please. It's out of time. It's been 2020, it's 12 years now, so we're out of time.
Very well, Lily. The next question is, please, has the use of ICT, example video link, been considered in trials when feasible? Just to save time, this from AK or to Esquire.
Yes. You see, it is feasible. It is done. Actually, what is happening is that because there's no specific legislation on the use of video link, but we have been going to the Chief Justice for a warrant pursuant to Section 69 of the Courts Act. So if you look at Section 69 of the Courts Act, Section 69 says that evidence may be taken in longhand, in shorthand, in voice recording, or by any other means mandated by the Chief Justice. So that is what we've been going under. So that if the CJ says that you may record it via video link, then we take the evidence via video link. But you need to, in case management, for example, have a request put to the judge that we plan to take evidence via video link from so and so person, in which case the judge quickly writes to the CJ for a warrant to take evidence via video link. Normally, in 2 days, the warrant would be delivered for Accra, maximum 2 days. And then with that, we'll take the evidence via video link. We've been taking evidence even in the law court complex. The evidence can be taken via video link without even moving out of the courtroom, because they will just bring their modem and set it up there. They take the evidence via video link at normal speed. When it is done, then the recorders transcribe it as part of the record. So then they'll show it to you. So it's done. It can be done.
Thank you, my lady. More questions are coming. It means that the participants are actually enjoying the session. The next question is, this daily trial, how feasible will it be? Preparation for a particular witness takes some time, especially where you need to consult experts in a particular field. Why not consider 2 trial days in a week, especially, my lady?
It is very feasible. Please, whatever expert you want to consult, you should be consulting, because we have already given you the disclosures. You already know what everybody is coming to say. So whoever you need to consult, you consult in the preparatory period. You don't need to wait for the trial to commence before you have your conferences. About preparing witnesses, we were all lawyers. I was a lawyer before I became a judge. I did many cases. I do not think that we need to wait until a trial is underway before we can actually go ahead to do anything. Day-to-day trial, is it possible? It's very possible. At least sitting in the financial crimes court and for doing civil cases as well as criminal cases, we saw that it was possible so long as you have given them the notice, they have the case completion plan. So that is it. I remember once having to do a case with my learned senior, Kwame Boafo. We had done the case completion plan. I think his junior was the one who did it. But once we were done, it wasn't a criminal matter. I said, we only saw that we had 2 witnesses in the matter. I said, for 2 witnesses, we'll do it in a day. And then we started by lunchtime. My senior said he wanted to go and have lunch. I took a break. I think after 40 minutes or an hour, we came back. The next witness started. He started saying he wanted to seal the person because he had a flight to catch. I said, no, that's not how it's done. Once we have a plan in place, we keep it. Anybody who has worked in certain courts knows that what I'm saying is done. It's just that sometimes I think some of my colleagues, they don't want to offend you lawyers. So in order not to offend you, when you have had a plan and you have a date, you've got a date, you fixed everything, you have a plan, then all of a sudden you come up with all manner of excuses, and then the lawyers say it's okay, the judges say it's okay. We cannot control our proceedings in such a manner. Now, you know that many of you travel abroad on holidays. When you go abroad, you know it, that you have friends who would have fixed their trials for months or weeks or on end. And when you go there, they leave you in the house and they go to the court. Some of you follow them and sit in the well and watch. When they fix their trial period from day to day, 5 days, 7 days, whatever, they don't budge. We also have many of us who are who are practitioners of law in other countries. Some of you are British trained lawyers. You have worked in the UK. Some of you have worked in the US and Canada. In all those places, you were happy to abide by those rules. Somehow, there's something about Ghanaians which is very relaxed and chill, such that for some reason, oh, here we can do it. We can do it. We can do it. It is nothing that it is not beyond us at all. We can do it from day to day, all day, like that. I have done civil cases in which have lasted 4 months from the day of filing to the day of judgment. I have done several, many. As for criminal cases too, I have done many. It is possible to do the cases from day to day, all day, as we have been directed to do. So please, let's try and comply. By the way, what is we have proposed also is that if the cases are so many, we need to clear the backlog. We have too many backlogs, such that witnesses may even die. If the CJ thinks it fit, that judges who sit in other courts may also sit and do criminal cases, she may direct it. If she thinks that judges in the Court of Appeal, Supreme Court, wherever, who might be a little free and may have 5 days, 10 days to spare to come and sit on a case, she will direct it. But we need to do the cases from day to day. Who keeps an accused person who is presumed innocent on trial indefinitely? It is not fair on them. It's not fair on the victims. It's fair on anybody. So it can be done. So I think that I'm sure that when you meet at the bar conference this year, you'll be able to give some feedback as to whether we are doing well or not. Thank you very much.
Thank you, Milady. I think we'll certainly give some feedback and let you know what we are doing. But there's a follow-up question on the day-to-day trial. And this has to do with cases where, as the trial is ongoing, we have mini trials as well. So the question is, there is a practice where defense lawyers make accused persons deny their statements to the police, especially confessions. So how do you factor mini trials in this 30-day trial arrangement, day-to-day trial that is being proposed?
For instance, counsel, if someone says that someone objects to a statement, the judge even has to take a look at the statement. If the statement is not a confession, by the rules, there's no need for a mini trial. You take a look at the section 120 of the Evidence Act. It is only when it is a confession that they need to now pay attention by having a mini trial. And in such an instance, if, for instance, the person objects to the statement in the morning, yes, please, I'm in a meeting. When I finish, you can put off the generator. Oh God, I'm sorry. So, in such an instance, you have to then fix the mini trial for the next available slot, afternoon, morning. Then you proceed from there. But there should be such a concentration and focus. I think, this thing that we are talking about, the Nigerians have actually passed legislation on it. But we are not, I don't think we are having the kind of focus we are supposed to have. But in such cases, we should be able to do it in the next few days. Mini trials, everything. How long will a mini trial take? After all, if you look at the decision in Frimpong alias Iboman, I think that I'm sorry. So please, if that is the case, what we are supposed to do is, from the decision in Frimpong alias Iboman, Justice Doche said that they should make sure that the kind of independent witnesses they get will be people who will be on hand to be able to help them to do their case. So nobody is giving concessions to the prosecution, neither are they giving concessions to the defense. I think that when we met in all the regions, we've told them, if we ask you to call your witnesses, you don't call them, we'll close your case for you. If we ask you to submit bring whoever you don't, we will close your case for you. If the case is at a level where no evidence has been taken, the accused person will be discharged. We'll just carry on. But we cannot have those cases pending forever. We can't. Please, can you excuse me for a minute? Let me switch to Ghana ECG, please.
Very well, lady.
Yes, let's proceed, please. Any more questions? I see that there are some 2 hands up.
Yes, lady. Yes. So there are more questions, and the next one is your leadership. Every day trial is a progressive directive, and I personally welcome it. But I wonder how defense lawyers will cope economically. Lawyers survive by having to juggle cases in different courts at different locations. Having to sit in on one case for a prolonged period will create economic difficulties for defense lawyers. Lady, I think this is for your comments.
I'm sorry, but I have never done private practice, so I don't know how you people make your money. I've never done it. I don't pretend I know it. But then I am just looking for this decision by Justice Brobe on adjournments and the issue of lawyers having to juggle. Justice Brobe once stated in one of the cases let me find it. Yes, that if a lawyer decides if a lawyer decided to embark on sole practice and was confronted with a situation where he had to appear in 2 different courts at the same time, he had himself to blame. Such practice could not inure to his advantage in the court. The decision is Mensah against Mensah. 1992-1993 Ghana Bar Reports 1432 at 1438. So please, the lawyers, I have seen last year alone, we had 1,400 new lawyers being called to the bar. I was at the call. So I find it difficult to understand how lawyers still want to do work all by themselves. There are many young people ready to work. So please train them and use them. But you can't still be doing solo practice in this modern age. And it's the same thing even for prosecutions. If they are going, I don't know why one person would want to go. You move in a team. Yes, Mensah and Mensah. Thank you very much, Mr. Agura. So please, you cannot do solo practice. So the juggling, I beg you, don't juggle. Please, just get the work done. In any case, it is just a few days, 5 days, 10 days. It will not kill your business. You will, please. So please, let's try and work. You know, many of us are so used to doing things in a certain way that whenever there is a need for change, there are many people who have a certain aversion for change. It is natural. Nobody wants to change. But then once the change comes in, later you realize that it was quite beneficial. So please, we will not collapse your business. Actually, the more diligent you are, the more cases I suspect you will get. So we'll pray that the Lord will bless the work of your hands and you will do well. Thank you very much.
We have a question that centers on AI. And the question is, what role will artificial intelligence play in the speedy prosecution of a criminal matter?
You know, I'm trying to write a paper on AI from start to finish in the criminal justice sector. How you will deal with bail, how you will deal with everything else. But for now, we are trying to see whether we could get funding such that we will have, for instance, speech to text, speech to text in actually taking the evidence, for example, so that the writing and the slow typing might stop. So, but for now, we have business. We are trying to get not just artificial intelligence, but many kinds of technologies. We have started, as I'm sure you've seen, because the ECDS, the electronic case management systems, and all that. That is the step we are taking. We have even in the Court of Appeal very soon we'll go off writing. Many of it will be electronic. We've already done training for it. So we have started. We have not yet attained the goal we want to attain, but we will. In the interim, whatever is available, we do. So in my case, for example, throughout the period I sat as a high court judge, I always did voice recording. There was no day I did not do voice recording. And initially, the voice recorder was given to me by the office. But once it's gospel, I replaced it myself because the voice recording really helps. Technology always helps, such that if somebody is speaking at a very fast pace and we keep telling them, oh, slow down, it's better for us to voice record and transcribe. And then sometimes I just want to listen to the evidence while I'm writing the decision. It helps because you want to check the voice inflections, everything else. The black and white print does not capture the emotions, the inflections. It doesn't capture anything. So we are moving on. The technology is still being used. Many of the courts still do voice recording in addition to the typing and so on. But at least you do know that with the instantaneous transcription, we now have proceedings being ready far, far earlier than the situation was in the 90s and early 2000s when we joined. So we are improving daily. Thank you very much.
4 questions, Milady. The next one is, the main challenge is that in the rural areas, the police prosecutors use the time-wasting tactics to delay trial for several reasons best known to them, sometimes with the tacit support of the judges. How can we ensure that these changes are effectively followed in rural areas? Lady.
For now, because we are dealing with trial on indictments now, there are no rural areas where trials are done on indictment because all the cases are heard in the regional capitals, which are not rural areas. So for now, at least for that, I know that there is some medium to long-term plan to replace police prosecutors with lawyers. Kenya has done it maybe 4 or 5 years ago. So Kenya no longer has police prosecutors. I think they did it progressively over time. I don't work in the AG's office anymore, but I remember even when I was there was a plan. And many, many years ago, they even built district offices of the office of the Attorney General. So when I was in Koforidua, for example, we had an office we built in Nkoko and another one that was built in Achimda. In Kumasi, there was one built at Asante Mampong and another one was built at Obuasi or so. So I know that over time, there will be no state prosecutors who are police officers even. It's just a matter of time. Of course, we are a developing nation. So whenever we have plans, we also have to have the money for it. But I know that over time, things will not be like they are now. Things will improve. Even now, things have improved. Remember, there was a point that I worked in Kumasi that we were 3 attorneys in the office. But the last time I went to Kumasi 2 weeks ago to do a similar sensitization like I'm doing with you now, I was told there are 20 or so, or more than that. I was impressed with it. So I know that over time, things will improve. But it's not as if we are not aware that there are things that ought to be done, which we are not doing. It's just that they are in the planning stages. So I'm sure there'll be improvements over time.
The next question is, what is the rationale behind trying rape cases by jury, but trying defilement cases summarily?
Please, there is a Court of Appeal decision on it. It came from the Kumasi Circuit Court. Forgotten the title, but I remember when Mr. Pobi was my boss and I was the deputy, we made an attempt with the same thinking that since defilement was even punishable by 7 to 25 years, as against rape being 5 to 25, we would try a rape case summarily. We tried it at the circuit court before now Justice Amuyati, and the matter was appealed on. And initially, I think the High Court affirmed it, but the Court of Appeal set it aside because rape is classified as a first-degree felony. Now, rape, robbery, and all those cases used to be in the same class until in the specific case of robbery, there was an amendment, NLCD, it's not in my head, but I'm old, so there was an amendment which specifically said that even robbery would now be tried summarily, and then the punishment was prescribed. So for now, it is just because of the classification of the offense. The offense is classified as a first-degree felony, similar to terrorism, terrorist financing, and all that. It is triable on indictment, either with the aid of assessors or with a jury. That is it. So the Court of Appeal has decided on it that decision was made ultra virus, so it was set aside. We have tested it. It did not work. So it has to be by judge and jury.
There's another person here who says that an accused person be represented by counsel during trial in absentia.
Yes. Yes, they can.
The next question, I believe, was possibly addressing your presentation, but is that it appears some jurors are not able to retain a decision for a long time because of collusion to break in more allowances. Other jurors go on strike because they have become professional jurors. Is it not worth considering widening the jurors' service for more citizens to serve? And I believe this was.
I think you are making a positive comment that widening it is the only way to go. Widening it was the only way to go. There was nothing else. This this thing that we had, just using civil and public servants, it wasn't the way to go. This is the only way to go. Yes, please.
I think we've come to an end of a rather interesting session. And I'll hand over to our Secretary, Mr. Joe Arnold.
Okay, my lady. Sorry.
And there's one last question that I want. Is it advisable to furnish the jurors with copies of the witness statements of the accused and the prosecution? No. I have already said that we are not supposed to bombard them with paper. We are supposed to read the witness statements to them. Then they will get the evidence in chief. And then they will listen to the cross-examination. We are not supposed to be giving them submissions written by lawyers and all that. No, it shouldn't be so. Thank you very much.
Okay, my lady, we are most grateful. The Greater Accra Bar is very grateful for your very useful presentation. We are sure we can count on you in the future for more enlightening sessions. Thank you very much, my lady. Now,
thank you to counsel. Thank you very much. I really appreciate your time. Thank you. And I'm going to report to my boss that at the highest count that I had, there were 555 of you.
My lady, we have 566 at a point.
Okay. Okay. Thank you very much. I appreciate your help. Thank you very much.
My lady, we are very grateful. Now,
so may I leave you now while you do your announcement?
Yes, my lady. Just one announcement.
Thank you very much. Thank you very much.
Now, dear colleagues, we are having a general meeting on the 16th, of April, and that would also have another CLE on collecting and preserving digital evidence. We'll share the details with you as usual via various social media handles and then your email addresses. Thank you very much for participating in this session, and we look forward to having you on the 16th of April as per the communications that will follow up. Thank you very much.